May please, Your Lordship, I beg to mention item 12.
Yes, what do you want?
Lordship, I beg that this matter may be fixed on 30 of March, next Thursday.
12.
Yes.
What about the other side?
Lordship,
No
I have
objection.
taken
No
the...
objection?
Yes, consent.
All right, as paid for by Ms. B. Shukre, learned additional AG, appearing for the state respondents, and not objected to by the other side. This is the matter again on 30th of March, 2023.
Okay, much obliged. Lordship, again, I beg to mention item 20 and 21. Your Lordship, in this case, AG is appearing and he's in bereavement. So, Lordship, I pray that this matter may be listed on 8th of May. I've taken the
Other side?
consent. Yes,
8th of May.
yes, Lordship.
What is this matter? Criminal, civil revision?
Yes, civil revision, Your Lordship. The trial court has passed the injunction without jurisdiction, so we have come in here, Your Lordship.
Okay, filed by the
Yes.
state.
Yes, filed by the state.
Please write down. The learned advocate general who is appearing in the matter for the appellants is said to be in bereavement. To stop on a prayer made on his behalf by Ms. V. Shukre, learned additional AG, and not objected to by the opposite party. List this matter again on 8th of May,
Yes,
2023.
Much.
May I please, Your Lordship? Lordship, I beg to mention item number 2, Lordship.
Yes. What do you want?
Lordship, here my senior will be arguing this case, but he is indisposed, Your Lordship. So if this matter may be listed on 10th of April, my lord.
Okay. Mr. A. Zimomi, learned counsel, who is leading the matter, is reported to be indisposed. On a mention made on his behalf by Ms.
Esther, Your Lordship.
Esther, learned counsel, assisting Mr. B. A. Zimomi, list the matter on
11th of April, Lordship.
11th of April.
Yes, Your Lordship. Lordship,
Yes.
I have a similar prayer for hearing item 46 also, Lordship.
46, yeah. What is this? This also on same day?
Yes, Your Lordship.
Similar order, huh? Item 46, like this, 2 and 3.
Lordship, I also beg to mention item number 6 and 7, Lordship. I'm for the petitioner in this case, Lordship. I'm yet to file my reply, Lordship.
How
So
much time?
3 weeks may be granted, Your Lordship.
Further 3 weeks' time is granted.
May I please, Your Lordship? Lordship, I'm appearing for respondent number 8 and 9 in item number 8 in 50 and item number
Huh. Yes. So, you have objection?
yes, Lordship. I have an objection. They are seeking time for more than
All right, then you take a shorter time. But you need to file a reply if you have to file
Yes, Lordship.
2 weeks' time.
Actually, in item number 7, Your Lordship, the state is said to file the counter also, Your Lordship.
Which item?
Item number 7, Your Lordship.
Lordship,
6 and 7 are analogous matters, Your Lordship.
So you said you'll file reply, then
Yes,
if
Your
they have not
Lordship.
filed counter, what reply will you file?
They have filed in 6, Your Lordship.
But in
Lordship,
7,
they are seeking time for filing rejoinder. And
Yes, Your
they have been seeking time for more than 3-4 times. So last chance may be given.
and government side?
Lordship, I'm told that WPC 204 is item number 7. Here, the state has already filed counter, and this particular affidavit will cover the other matter. That is 50/2022, item number 6, Your Lordship.
So I'll record that.
Lordship.
Ms. Esther, learned counsel, for the petitioner, prays for 3 weeks' time to file, further 3 weeks' time. Further 3 weeks' time to file affidavit in reply to the affidavit opposition filed by the state respondents in WPC number 204
Yes, Your Lordship.
of 2021. Is it correct? 204 affidavit in
Yes,
204?
Your
And
Lordship.
50 you have not filed?
No, Your Lordship, because 204 affidavit will cover the other matter, Your Lordship.
To this submission, Ms.
Mabini.
Mabeni, learned counsel appearing for the private respondent has raised objection, stating that the petitioner has been taking time on regular basis, and if time is to be granted, it should be as a last chance. We'll stop. Mr.
In Angami, madam.
N. Angami, learned
Government advocate.
government advocate, appearing for the state respondent, submits that affidavit in opposition has been filed in 204 of 2021 WPC, huh? And the same will cover the stand of the state respondents in WPC number 50 of 2020. Stop. Next para, considering the submissions made, the petitioner is granted
3 weeks, Your Lordship.
3 weeks as a last chance
Lordship.
to file a rejoinder affidavit. List the matter again after 3 weeks. If affidavit is not filed by then, court may consider proceeding with the matter on the basis of materials available on the court.
Lordship.
All right?
Obliged, madam. May I please, Your Lordship? Lordship, I beg to mention item number 34. Item 34, Your Lordship. I'm for the state respondent, Your Lordship. I'm here to receive instruction in this matter. If 3 weeks' time can kindly be granted to me, Your Lordship.
Lordship, 3 weeks' time may be too long, Lordship. On the last occasion also, they were given 3 weeks' time to get instructions, Lordship.
This
Give
is
2 weeks.
2022 matter,
Yes, Lordship.
2022 matter.
May I please,
So grant
Lordship?
them one more chance. Yes.
I'm for respondent number 4.
Yes.
Private respondent, I'm also yet to file my affidavit. Can grant me 3 weeks time, Lordship.
Although objection has been raised by the learned counsel for the petitioner, stop, since the matter pertains, since the matter since the case is of the year 2022, further 3 weeks' time is granted to the respondents for filing their counter affidavit, with the understanding that the counter affidavit will be surely filed within the given time.
Even for a private respondent, Lordship.
Yes, I said respondents. 3 weeks' time.
Yes, Lordship.
Yes.
Lordship, I also beg to mention item number 41 on behalf of additional AG V. Shokre.
Oh, she was here.
Yes, Your Lordship, she is attending to one of our matters in the court number.
Okay,
Yeah.
okay.
If 3 weeks' time can kindly be granted, Your Lordship, I'm told that she is here to file this, her counter affidavit, Your Lordship.
Yes. Anyone for the other side?
Lordship, I pray that 3 weeks' time may be given to file an affidavit in opposition regarding respondent number 2, 3, and 4.
In item 41?
Yeah.
Okay, we'll grant to all the respondents. As prayed for by the learned counsels for the respondents, further 3 weeks' time is granted for filing counter affidavit. List after 3 weeks.
Deeply obliged.
Yes.
Lordship.
Any other mention?
Lordship, I beg to mention item number 43. Lordship, I pray that the matter be listed after 1 week. Since
Why?
my seniors are out of station, and the letter of absence is also reflected in the cost list.
Okay. Mr. Gauhati, learned counsel for the petitioner, is reported to be out of station, and therefore the matter may be posted after a week. Stop. No. And therefore, the learned counsel, Mr. Give in writing. Mr. So-and-so, prays that the matter may be adjourned for 1 week. Stop. It is also seen that Mr. Gauhati has submitted leave of absence up to 24/3/2023. Stop. In view of above, list this matter again. In the week commencing from 3rd April,
Yes, Lordship.
in the first week of April, say that. Yes.
Obliged.
May I please, Your Lordship? I would like to mention item number 23 and 24.
Yes.
I pray that 2 weeks' time may be granted to file affidavit in reply because I received the affidavit in opposition on this morning.
As paid for by the learned counsel for the petitioner. How much time?
2 weeks' time.
2 weeks' time is granted for filing rejoinder affidavit to the affidavit in opposition filed by the state respondents. List after 2 weeks.
Oblige, Your Lordship.
Please, Your Lordship.
Yes.
Lordship, may be pleased to mention item number 19.
19.
Lordship. Lordship, let the matter be listed on Monday, Your Lordship, for admission hearing. Lordship, I'm having some personal difficulties today.
Mr. Senti.
I have no objections, my lord.
All right. 19, you write, as prayed for by Ms. Devika, learned government advocate, and not objected to by the Mr. Senti Younger, learned counsel for the petitioner. List the matter again on 27th of March 2023 for admission.
Thank you much, Your Lordship.
Admission hearing, my lord.
Yes, admission.
Obliged, my lord.
May I please, Lordship? I beg to
Yes.
mention item number 45 from the hearing list, my lord. I have instructions to appear for the respondents number 1, 2, and 6. That is the Nagaland University. So I may be given 2 weeks' time to file my Bakalatnama
Which case?
in item number 45, my lord.
45. Are you the standing counsel?
Earlier, I was the standing counsel, but my standing, it was discontinued. Now they have approached me to appear in this case
In particular,
in my personal
your good name, please.
N. Longkumar, my lord.
Mr. N. Longkumar, learned counsel, submits that he has instructions to appear on behalf of Nagaland University. Who is arrayed as respondent?
1, 2, and 6.
Numbers 1, 2, and 6.
Yes, my lord.
And therefore, he may be given
2 weeks' time, my lord.
2 weeks' time to file his power and prepare the matter.
Yes, my lord.
Mr. Poseko Fote, learned counsel for the petitioner, has no objection to the prayer. In view of above, list this matter for hearing after 2 weeks.
Obliged, my lord.
May I please, Your Lordship? Your Lordship, in item number 28, Your Lordship, here the state is yet to file counter. So kindly grant me 3 weeks' time, Your Lordship.
28. Any objection?
No.
All right, as paid for by learned government advocate. Further 3 weeks' time is granted for filing counter affidavit on behalf of the state respondents.
Much obliged, Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 9 on behalf of my senior, Yushia. Kindly let this matter be passed over for the day.
Okay. Item 9, the matter is passed over for the day on the request made by the learned counsel for the petitioner.
Much obliged.
May I please, the Lordship? Lordship, I beg to mention item number 18, Lordship. Here, the state is yet to file counter affidavit, Lordship. 3 weeks' time may be given, Lordship, to file counter affidavit. Item 18, Lordship.
It's 21 matter. 2021 matter.
Lordship.
May I please, Lordship?
Yes.
Lordship, I'm appearing on behalf of respondent number 5.
Ah.
Lordship, may this be the last chance given to the amendment?
Lordship.
All right,
There's
further,
emergency.
on the prayer made by learned state counsel, further 3 weeks' time is granted for filing counter affidavit of the state respondents as a last chance.
Lord.
List after 3 weeks.
Lordship, I have similar prayer for item 25, Lordship. Three weeks' time may be granted to file counter affidavit.
Okay, 25, similar order without the last chance.
Hello.
Lordship, I beg to mention for item number 4 on behalf of counsel for the petitioner.
Item number 4,
Yes, Lordship. Yes, some personal difficulty.
who has
Kindly list the
difficulties?
matter after 1 week.
who has difficulties?
The petitioner, Mr. Pakin. Mr.
Pakin.
Pakin. Yes, Lordship.
See, one thing is that there's some similar matter pending before the Supreme Court. So what is the status that has to be informed to the court? Mr. Pakin, learned counsel for the, give the full name, huh? Learned counsel for the petitioner is reported to have some personal difficulties. Stop. On the prayer made on his behalf, matter stands adjourned for a week. Stop. On the next day, learned counsel for the petitioner shall inform the court about the status of the matter which is pending. Status of the similar matter which is said to be pending before the apex court. Yes.
Much obliged.
May I please, Lordship? My Lord, I beg to mention item number 42. My Lord,
Yes.
here I am appearing for private respondent number 5. I'm told that the petitioner's advocate counsel is out of station. So if this matter can be listed on 28,
This next Tuesday.
my Lord.
All right. You are for the,
I'm for the respondent number 5.
okay.
I'm told that the petitioner's advocate, the counsel, is out of station. So he has asked me to list the matter next week.
All right, as paid for by the parties, list this matter again on 28th of
Bless me.
March 2023. Yes.
Please, my lordship, I beg to mention item number 46. Lordship, I have some personal difficulties today, so.
You were here. It was already mentioned.
No, lordship.
2 weeks, already adjourned.
May it please, Your Lordship, I beg to mention item number 11. I am mentioning on behalf of Ms. Nuksang Tila, counsel for all the respondent. This is respondent 1 to 5. Your Lordship, on 21/3/2023, we have received affidavit in reply. However, Your Lordship, the term for the railway advocate has already expired. Until date, a new counsel is yet to be appointed, and as such, Your Lordship, I pray that a notice may be issued to the respondent.
Which respondent?
There are 5 respondents, Your Lordship. The railways,
No notice will be issued to which particular respondent?
to the railways, to all the respondents, 1 to 5. Since all the respondents are represented by one counsel.
Let
Mr.
us see the
Santila.
file. See, no point sending the notice to everyone. If one person
Yes.
is sent, this is enough.
Yes, yes.
If there are 5 respondents, all from the railways, who is the
Yes, Lordship.
responsible officer or the respondent which will be relevant for the purpose of notice?
General Manager, Northeast Railway, Maligaon.
All right. What, this is item
Item number 11, Lordship.
11. Who was the previous counsel?
Ms. Nuksang Tila.
Okay. It is submitted at the bar that Ms. Naksung Tila, learned counsel who represented the railways, is no longer the counsel, as her term of appointment has expired.
Lordship.
Stop. Next para. In view of above, registry shall issue notice to the respondent number 2, that is the general manager, Northeast Frontier Railway, Maligaon, Gauhati, Assam, about the pendency of this case, asking the state authority to make alternative arrangement. List the matter again. We'll fix a date on 24th of April, 2023.
Much obliged, Lordship.
Obliged, my lord.
May I please,
Yes.
Lordship, I beg to mention item number 35. Lordship, I'm appearing on behalf of private respondent number 7. So if this court may allow 3 weeks' time for me to file my affidavit, Lordship.
If my lordship,
Yes.
Lordship, if I can make a small prayer, Lordship.
Yes.
Lordship, on 15th of December last year, it was made sure that respondents will file affidavit one before the next hearing date. Again, it was listed on January. And Lordship, there is urgency in this matter because my junior has been promoted, whereas I'm still in the same position, Lordship. So if a shorter date may be given, Lordship.
2 weeks.
Lordship.
You are for which respondent?
Respondent number 7, Lordship.
Your good name?
Lakney Pom.
Mr. Lak Ye Phom, learned counsel for respondent number 7, prays for 3 weeks' time to file affidavit in opposition.
Lordship.
To stop the said prayers objected to by the learned counsel or the petitioner on the ground that several opportunity has been granted to the respondent number 7 for filing counter affidavit. Next para, considering the submissions made, further 2 weeks' time is granted as a last chance to the respondent number 7 to file counter affidavit. List the matter again after 2 weeks.
Much obliged, Lordship.
All right. Please file.
May I please, Lordship? Lordship, I beg to mention item number 29, Lordship,
Yes.
on behalf of Pichano. Lordship, I'm yet to receive instructions, so kindly grant me 3 weeks' time, Lordship.
29.
Lordship.
Your Lordship, item number 29, 30, and 31. That is WBC 182, 183, 184 of 22. It's an analogous matter, Your Lordship. So I pray that this matter may be come up along with one WBC 130 of 2022, which is also pending before this court, Your Lordship. These all are similar matters
130.
of 2022.
Now, affidavit is filed in all the cases except for 29, or none of the cases are with
No,
affidavit?
Lordship,
None
yet
of
to
the
file, Your
cases-
Lordship.
None of the
All right.
cases, Lordship.
As prayed for by the learned government advocate, how much time?
3 weeks, Lordship.
3 weeks' time is granted for filing counter affidavit. List the matter again after 3 weeks along with WPC number 130 of 2022. Similar order in item 30 and 31 also. Okay?
Yes, Lordship. Much obliged.
Lordship, I also beg to mention item number 38, Lordship. On behalf of Bishop Additional AG, Lordship. Lordship, I'm here to receive instructions, so kindly grant me some time, Lordship. 38.
How much time?
3 weeks, Lordship.
As prayed for by the learned state council, further 3 weeks' time is granted for filing counter affidavit. Yes.
Lordship, I also beg to mention item number 13, Lordship. On behalf of Tipapom, Lordship.
13, 1-3.
Lordship. Lordship, here I'm here to file my counter, so kindly grant me some time, Lordship.
Yes.
I have no objection, Lordship.
As prayed for, further 3 weeks' time is granted to the state for filing counter affidavit. List after 3 weeks.
Much obliged.
Lordship, I also beg to mention item number 39, Lordship. On behalf of Lucy, Lordship. Kindly grant me 2 weeks' time, Lordship. Pleadings are complete, Lordship.
39.
39, Lordship.
Why is it listed for orders today? Otherwise,
Your Lordship, as of order dated 13/9/2022, it has been listed for admission hearing.
but this is listed for 30 orders today. Can we just have a look? Item 39. The list out of winter vacation. And
Your Lordship, here respondent 4 to 15 are both from our respondents.
So have they been served?
Affidavits of respondent 1 to 3 has been received, Your Lordship.
No, that is okay. I'm asking you whether the private respondent numbers 4 to 14 have been served or not. It seems that they have not been served.
No, Your Lordship, not yet. However, Your Lordship, as of order dated 13/9/2022, it is of the view that this case may be listed for admission hearing. Hence, it was fixed for admission hearing.
Because there was a submission made by
Yes,
the
Your
counsel
Lordship.
for the petitioner that Mr. Likase Sangtam,
Yes, Your Lordship.
appearing for the petitioner, submits that the matter can be taken up for hearing since the affidavits of the main respondents have been filed. And in any case, the rights of the respondent numbers 4 to 15, who are pro forma respondents, would not be affected. How do you say that? Are they pro forma respondents?
Yes, Your Lordship.
So what is your prayer?
To be listed after 2 weeks, Lordship.
Any
No
objection?
objection.
All right, and the prayer of the Learned State Council, and not objected to by the opposite party, list this matter for admission after 2 weeks.
Obliged, Your Lordship.
Lordship, I also beg to mention item number 27, Lordship. On behalf of Sir Moa Imchin, Lordship. Lordship, kindly grant me 3 weeks' time to file my counter, Lordship.
Yes, 27 as prayed for, 3 weeks' time is
My
granted.
lord, this is a covered case. As per the decision passed by the Honorable Supreme Court in Chakjit Singh's case, my lord. So I believe no affidavit is necessary. If the government can come with instructions on the next date instead of an affidavit, because affidavit, I believe it will require more time. I have also.
Do you have the citation?
Yes, my lord. In
Mr.
my-
Sentiang, please write. Mr. Sentiang, learned counsel for the petitioner.
I have reproduced
Submits
it in my
that
petition.
the matter is covered by the decision of the apex court in
State of Punjab versus Jagjit Singh.
State of Punjab versus Jagjit Singh.
2017 1 SCC 148.
2017 1 SCC
148.
148.
My lord.
Stop. On the other hand, learned state counsel prays for 3 weeks' time to file counter affidavit. Next para. Considering the submissions made by Mr. Sentianger, matter be listed again after a week. Learned government advocate shall examine as to whether the present case is indeed covered by the case of Jagjit Singh, Supra.
My lord.
List after a week.
Much obliged.
Minimum pay, isn't it?
Yes, my lord.
I'm told that there are a lot of cases pending here.
My lord.
Minimum pay.
My lord.
People appointed and they claim for minimum pay as per Jagjit Singh.
Yes, yes.
And Jagjit Singh has been
so
cited
far-
by this court also in that writ appeal.
Yes,
In the
yes.
principal seat, there was one writ appeal.
Okay. But so far as I know, for me, I am handling only this particular matter relating to this issue.
There are other matters
My
also
lord,
I've
my
come
lord.
across.
My lord.
Yes. Anyone
Obliged,
else?
Yeah, Lordship, I also beg to mention item number 37, Lordship.
37.
Lordship, on behalf of Mo Indian Lordship.
How much time?
3 weeks, Lordship. Apology, Lordship.
Not this case. Not this case. Okay.
May I please, Your Lordship? I beg to mention admission item 14, 15, 16, 17.
Oh.
Your Lordship will
Wholesale.
14, 15, 16,
Oh, these
17.
are all clubbed together.
Yes, Your Lordship.
Mm.
Your Lordship, we received an affidavit in opposition to this, for which Your Lordship may kindly allow 3 weeks to file affidavit in reply.
All right. The learned counsel for the petitioner submits that she has just received the counter affidavit of the state respondents and therefore she may be granted 3 weeks' time to file rejoinder affidavit. The prayer is granted. List the matter again after 3 weeks. Reply affidavit be filed in the meantime.
Much obliged.
Yeah, please, Your Lordship.
Yes.
Lordship, may I be pleased to mention item number 5. Your Lordship, I'm having some personal difficulties today, so let the matter come up on Thursday.
But Mr. Jamir is here. Have you informed him?
Yes, I've taken the consent, Your Lordship.
But he has also not filed his reply affidavit.
We have filed, Lordship.
You have filed?
Yes.
I see. How much, when do you want it?
Thursday, Your Lordship.
Thursday.
Thursday, next Thursday. Why not Tuesday?
Tuesday,
I'm okay.
28.
28, yes.
I have some difficulty, Lordship,
Oh.
on 28. Otherwise, 27 also, it's okay.
What do you say?
No
Okay, as prayed for by Ms. Livika Lanet, State Council, and not objected by the opposite party, list the matter again on 27th of March 2023.
Much obliged.
Yes.
Lordship, I beg to mention item 10. I am yet to file my affidavit in reply to the affidavit.
How much time?
3 weeks, my lord.
Any objection from the other side?
No, my lord.
All right. As paid for by Mr. Sentianger, learned counsel for the petitioner, further 3 weeks' time is granted for filing rejoinder affidavit. List after 3 weeks.
Deeply obliged, Lordship.
Yes.
Lordship, I beg to mention item number 8. Lordship, the pleadings are contemplated and such that matter may be fixed on 27 March 2023 for admission hearing.
Okay, it is submitted by the learned counsel for the, you are for which party?
Mr. Young.
He is for the petitioner.
Petitioner.
It is submitted by the learned counsel for the petitioner that the pleadings are complete and the matter will be posted on 27th of March 2023. Stop as paid for, list the matter on 27th of March for admission. Yes.
We have this, Lordship. Lordship, I beg to mention item number 36, Lordship, on behalf of my Indian Lordship. Kindly grant me 3 weeks' time to file my counter, Lordship.
May I please, Your Lordship? Your Lordship, in this matter, I believe counter may not be necessary.
Why?
Because, Your Lordship, the respondents have already stated in their order that I'm entitled and it is under consideration. However, the process of consideration is taking forever, Your Lordship. So I'm praying for a stipulated time frame. My prayer is very, very limited, Your Lordship.
All right, let the matter be called up, we'll see, all right?
Lordship.
As and when the matter is called up, we'll see whether time is to be granted or not. Okay?
Obliged, Lordship.
Yes.
For motion, item number 1.
Yes, Mr. Tompo.
Yes, Lordship, the present matter is a claim regarding land ownership. There was a settlement made with the department, which is at annexure H, page 27. Land was acquired from the petitioner's family in 2003. The government kept on postponing payment of the compensation. Then in 2016, the State Land Acquisition Board arrived at a decision to acquire the land for 8 lakhs. 8 lakhs, 8,25,000. Whereas the proposal made by the department was that since the the amount, the fixed rate by the rate fixed by the district administration comes to 250 per square rupees 250 per square meter, it comes to more than 33 lakhs. So that proposal was made. The State Land Acquisition Board decided no, 8,25,000 only. Then, after some back and forth, the department decided to have a settlement with the petitioner's family. And at the settlement, the agreement that was made was that a grade 3 post vacancy should be given to the petitioner's family as a one-time measure, and the petitioner's family will accept the decision of the SLA. That was a...
Please come to page 28.
Yes.
This is the agreement.
Yes.
Condition 1, 2, and 3.
Yes.
And
1,
this
2,
was agreed upon on which date?
on 7th of December, Your Lordship.
Okay, so this has not been honored till now.
No, this has not been.
In the meantime, what are they doing?
Now, in the meantime,
They're filling up some posts.
they have advertised 115 posts, which is at annexure N. This is dated 13th of January 2023.
Page?
Page 30, Your Lordship.
30.
Yes, this is the newspaper advertisement.
30 or 13?
13th January 2023.
No, page
The
number.
Page is 30. Last page, Your Lordship.
30.
Yes, 30.
The last page is 39.
Oh, yes, Your Lordship, it's 39. It's page 39, Your Lordship. So by this advertisement, 115 posts of forest cards have been advertised. No selection has taken place till date, Your Lordship. So aggrieved by this, without considering the petitioner's case, genuine case for so many years, my humble prayer is that the petitioner should be appointed against one of these posts.
Where's the numbers of posts given?
Your Lordship, in the first paragraph, in accordance with approval of the government of Nagaland, white letter number so-and-so dated 10th January 2023, issued subsequent to clearance from the BNAR, white number so-and-so, dated so-and-so, and concurrence of Finance Department, white RFC so-and-so, dated so-and-so. Applications are invited from eligible candidates for filling up 115 posts of forest guard under the Department of Environment, Forest and Climate Change, Government of Nagaland, as per the terms and conditions prescribed below.
So what are the dates, last date and all that? Date of selection?
No,
it is there, serial number 8, last date of receipt of application.
yes, serial number 8. The date, time, and venue of the examination shall be published in local dailies, and no separate call letter shall be sent to the applicants. So far there has been no publications.
So have you applied for this post?
Your Lordship, Since it is a grade 3 post, Your Lordship, and the agreement is that a grade 3 post should be, an appointment to a grade 3 vacancy should be given to the petitioner's family.
You see, the forest guard post is a grade 3 post.
Yes, Your Lordship. On 2 occasions, the petitioner's elder sister submitted 2 applications, in fact, and in one application, she has specifically mentioned that since vacancies of forest guards are available, she be accommodated against one of them. Then what happened was, in the meantime, she got age part. She became overaged for appointment in government service. So the petitioner submitted an application subsequently.
Petitioner is the brother.
Petitioner's younger brother.
Younger
yes,
brother.
Yes.
See, even if a post is promised to you, are you not still required to apply for the post?
No, we had already submitted applications, Your Lordship.
No,
So
no,
now if I apply, yes.
See, in terms of this advertisement, you submit an application.
If I submit
And
an-
then they may consider you on that basis, seeing you, since you're one of the landowner, like that.
If this honorable court may, yes.
Or
yes.
is it that since there's an agreement, you need not apply, they will come and invite you, come, this post
Yes.
is ready for you. Is it like that?
Yes, Your Lordship, if we submit an application on the basis of the agreement, it is for them to consider my case. So only in the month of August,
Now, this land is
Last
donated to the forest department.
Forest Department acquired it in
Acquired it.
2003. Yes, acquired it.
What about the money? Have you received the money?
Yes, we have received the money in 2016 December.
8 lakhs, 25,000.
Yes, Your Lordship, which is at page 29. Your
Okay,
Lordship.
number 1 is fulfilled.
Yes,
The number 2 is the appointment.
yes. Your
This is
Lordship.
not done.
It is not done.
And the number 3 is just a condition.
Yes, it's just a condition that it will be a
There-
one-time measure.
There are 2 notifications in 2018,
Yes,
which says that it cannot be in perpetuity.
yes, yes, yes.
Person retires,
Yes.
matter ends there.
Yes, Your Lordship.
You're not claiming that.
No.
You are claiming for the first time.
Yes, claiming for the first time.
Yes, Ms. Levika.
Lordship, but this may be issued, Your Lordship. Because,
And what about this 115 posts?
Lordship, I have to take instruction on that. And even with regard to the,
Keep 1 post vacant.
Your Lordship, I have to get instruction as to how this has come about, Your Lordship. Because otherwise we have a notification where it's.
All right, fair enough. We'll get instructions, but we'll consider this aspect on the next one.
Yes.
Mr. Hart, Mr. Dongpok Pongener, Learned Counsel, for the petitioner who submits that the land of the petitioner clan,
No, family.
petitioner's family,
Family, yes.
has been acquired by the Environment and Forest Department by way of an agreement which was arrived at, by way of a written agreement which was arrived at on 7/12/2016. Stop. One of the condition of the acquisition was that as a one-time measure, the department shall appoint one of a landowner to any grade 3 post vacancy arising against sanctioned post in the department. Stop. He submits that although 115 posts have fallen vacant, the respondent authorities concerned have not given appointment to the petitioner in terms of the agreement, and instead they have gone ahead in advertising all the 115 posts on 13 January 2023. Stop. He therefore submits that a direction may be given to the respondents to appoint the petitioner against one of the posts advertised. Next para, in view of above, issue notice of motion, returnable by 4 weeks. Ms. Livika, learned government advocate, accepts notice on behalf of all the
All the
respondents.
respondents.
Extra copies of the writ petition be furnished to her, if not already done. On the next returnable date, the learned government advocate shall obtain instructions about the claim for appointment made by the petitioner against a grade 3 post. And also the status of the advertisement dated 13/1/2023. Stop depending upon the instructions obtained by the learned government advocate. Court may consider keeping one post vacant if advised.
Muchas gracias.
For admission, item number 22.
Yes.
Please, Lordship.
You have prepared the list?
Yes, my lord, I have prepared a list.
You give one copy to your friend also, if you
Yes,
have.
my lord.
You may start.
May I please, Lordship. The prefect of the case is that the petitioner was initially appointed as handyman in the Department of Information and Publicity way back in the year 1970. Thereafter, he was appointed as accountant in the same department. While working as such, my lord, the petitioner was...
Just a minute. Where is that accountant?
My lord, the records are not available, my lord.
No, but in the list of dates, you should have indicated.
Yes, my lord.
Because from the post of handyman, you have gone straight away to inspector.
He was subsequently appointed as accountant, my lord.
So you should have indicated here.
My lord, despite my best efforts, even the petitioner is not aware of that fact. And then, as per the records,
Then why are you submitting?
I'm just a submission, my lord. But the issue pertains to the Industries and Commerce Department, how he was brought on deportation, my lord.
See, Mr. Counsel.
Yes, my lord.
Have you stated that he was appointed as an accountant in your writ petition?
Yes, my lord.
If that is the thing, then why did you include that in your list of dates?
My
So
lord,
that we can go serially.
Yes, my lord, but the documents are not available, my lord. And then
Maybe
exact
not.
date is also. So,
Maybe not available, but at
yes.
least you should have stated.
My lord, I have
In
stated...
which paragraph?
In paragraph number 2, my lord. Paragraph 2, my lord. Married, my lord. That the petitioner is retired government 7, retired as functional manager, Department of This is the offer, letter of offer, memorandum. By this memorandum, he was offered the post of Inspector of Industries. This is the offer letter, my lord.
I see. It's not legible, isn't it?
Yeah, I have annexed type copy, my lord, page 18, my lord. Here it, my lord.
Memorandum.
Yes, memorandum. Number so and so, dated Kohima, the 20th August, 83. The undersigned hereby offers Shri H. Penongpom a temporary post of Inspector of Industries in the office of the General Manager DIC Pinsang in the scale of pay of rupees so and so. The appointment will be also entitled to inner line compensatory allowance of so and so for the pay.
See, Mr. Counsel,
Yes,
you
yes,
have been
ma'am.
offered, this is a new appointment. It's a new appointment.
Yes.
Does it anywhere speak about your past
No.
service as handyman and
No.
accountant?
But this doesn't say anything about.
Then?
And then the next annexure B.
So from where will your service will be counted?
As per as authorities, they have counted my service from 1970, from the date where I was appointed as
They've
heavy man.
counted?
Yes.
They've counted.
Yes. My line of service was counted from that 1970.
Okay.
Because as per this
Now,
memorandum, I was brought on deputation.
Now, what seems to be the problem? See, if your service is counted from 1970
Yes.
and you ultimately retired on superannuation, on which date?
Yes. As per the lease.
27 July 2011. Correct.
Why not? As per the, if it is to be counted from 1970, it has to be from 31st December 2005, my lord. The annexure which I have given to your lordship.
Sorry?
It's in the list.
In the list?
Annexure, yes, my lord.
Yes. What is this?
As per this, my lord. Date of completion of 35 years of service. In column numbers, my lord, in column number 5, my lord.
Yes, column number 5.
Date of birth.
Date of birth, correct?
And then the column number 6 is date of joining government service. It's given 2/12/1970, which means they have conducted my line of service from my initial appointment, my lord. That's handyman.
So, at what age did you join the service? Were you underage?
No, my lord. I joined at age.
If your date of birth is 1952, and if you joined in 1970, how old are you? 18 years.
18 years.
Are you eligible as 18 years?
Yes, 18 and above, I'm eligible. my lord.
18 is the minimum?
Yes, my lord.
Are you sure?
Yes, my lord.
Right.
But,
Then,
my lord, the issue is that I've been released from service white order.
no, just come again to column number 7.
Yes, my lord.
Completion of 35 years is which date?
31st of 2005, my lord.
2005.
Yes, my lord.
But now you have been released,
In 2011.
but it says 31/10/2009. What is this date again?
This is the date for release attaining 6 years of age.
No, why like that?
My lord, this is because, my lord, I may be allowed to take your lordship to page number 31.
Then why 2011 again you were released?
My lord, may I take you to page number 31, my lord?
Is it the thing that you have overstayed?
Yes.
Overstayed in service?
They are saying that I've overstayed for 1 year and 9 months.
So what is the what is the age of retirement
Age of retirement is
for a government servant?
60 years, my lord.
60 years. So if your date of birth is 1952, you should retire on which date?
If it is as per 2012, my lord.
2012. Correct. But was it always 60 years or it was 58 years at some point of time?
My lord.
Was it 58 years at some point of time, age of retirement?
No, my lord. It was.
You were 60 years all along.
Yes, my lord. At that point of time, I'm not aware, my lord.
Then
but now-
how do they say that you have retired, you have overstayed your service? If
My
you
lord.
retired in 2011,
Yes, my lord. My lord, page number 31. This is the release order, my lord. This is the annexure is the continuation of this order, my lord. Page number 31, my lord.
yes.
Married, my lord.
Order number so and so dated 27 July 2011. Order. In terms of Section 3, Clause 1 of and Section 3, Clause 2 of the Nagaland Retirement from Public Employment Service Amendment Act 2009, which comes into effect from 31st October 2009, in terms of the Government of Nagaland PNR Department Notification number so and so dated 7 August 2009. The following employees of the Government of Nagaland serving under the Department of Industries and Commerce, whose names and particulars are enclosed in Annexure 1 are hereby released on retirement with effect from 31st 10 2019 to 2009 on completion of 35 years of service. This is the release order, my lord. And then in the last occasion, in the petition, I have not enclosed this annexure. So
No, you have not enclosed the list. Where is your name in the list?
only my name is there, my lord.
Huh?
Only my name is there in the list. Though they have stated that the names of
Names and particulars are enclosed in
Yes.
Annexure 1 are released.
Yes.
That means more than one.
More than one, it should be. But maybe there is a topographical error, my lord. But as per the annexure here, my lord, annexure, may I take your lordship to the annexure, the loose sheet. Annexure to the order number IDAE 14, IDAE 5 for 141/2001, dated 27
All right,
July
all right.
2011.
The date, everything,
Yes,
it tallies.
Italy's, everything. And then even the order.
All right.
So by this order, our cities with effect from 31st October 2009.
Correct.
Since my retirement, my pension was not paid to me.
Why?
Till now.
Why is not
For the
paid to you?
reason stating that I have overstayed for a period of 1 year and 9 months.
Okay, according to them, you should have retired on which date?
According to them, if it should be 2009.
No, 2009 you have retired.
But I was released only in 2011, my lord. Though the effective date is from 2009.
Okay.
I was
So,
released in
so
the
how long
2000
did you overstay? How long did you overstay?
1 year, 9 months, my lord.
1 year, 9 months or 19 months?
1 year, 9 months, my lord. My lord, since my pension was not released, I've approached this honorable court by filing WBC 150 of 2019, my lord. This is the third round of litigation, my lord.
Where is it stated? 1 year, 9 months? Is it in the counter affidavit?
Yes, my lord, it's in the counter affidavit, my lord. Counter affidavit of the state respondents, my lord. At page number 21, annexure 10,
No, the duration.
my lord.
The duration.
The duration is here, it's mentioned in the annexure.
Where?
The annexure
Page?
10, page number 21 of the counter affidavit of the state respondents, my lord.
Where is that?
Towards the last paragraph, my lord. The letter dated 26 July 2022.
It's hardly legible.
Its type copies enclosed at page number 22,
I
my lord.
see.
The next page. The last paragraph, my lord.
So 1 year and 9 months.
Yes, you are therefore directed to recover the entire amount you have encased as salary and other allowances during your overstay in service for 1 year and 9 months, as per the direction of the cabinet.
This is letters written to you.
Yes, this letter was given to me during the pendency of this petition, my lord.
I see.
Now I'm.
Why did you overstay service? What
Because-
was the circumstance under which you had overstayed the service?
My lord, I was just continuing service. It's not my fault that I've overstayed. They have replaced my service and then they have not checked my records, maybe. Because of that, I've rendered my service. I was serving. And then suddenly they have issued this release order.
Your accepted date of birth,
Yes,
which is not disputed, is 2/5/1952.
1952.
So the government servant has a service of 60 years.
Yes.
I mean, the age can serve up till 60 years.
Up to 60 years.
So 2012.
2002.
2002.
1952, 60.
2012.
Yes, 2012, my lord. 2012.
If it's 2012,
But I was made to retire on completion of 35 years of age, my lord, not by age. Either one, whichever is earlier.
according to what procedure?
According to this retirement of my lord, according to this, the Nagaland Retirement from Public Employment Second Amendment Act.
Have you
of
enclosed
2000.
that?
No, I have
somewhere?
not enclosed, my lord.
So how do we know? You must give us a copy. And is it indicated anywhere in your release order that you have
Yes,
been-
it's indicated in the release order, my lord.
Where
At
is
page
that?
number 31.
31. Where is that?
Page number
Section
31.
3.1.
Yes, my lord. In terms of section 3.1 and section 3.2 of the Nagaland Retirement from Public Employment Second Amendment Act 2009, it says either 35 years of service or 60 years of age, whichever is earlier.
Whichever is earlier.
Yes, my lord.
Show me that. Do you have the rules with you?
My
The
lord,
act, the act.
the act I don't have as of now, my lord.
Where will we find it? The act. See, you had been given time to organize your submission.
Yes, my lord.
Today again, I find some lacuna.
My lord, my apology, but I thought since my retirement is not an issue because I've accepted this release order.
No, here is a case where we are trying to settle your issue because you've come to the court third time. So we have to look into this matter from all angles if you are to be given some relief, isn't it?
Yes, my lord.
So is there any dispute regarding the provision here? If you serve 35 years or you're 60 years, whichever is earlier, you will retire.
Yes, Your Lordship.
Now, the question here is that whether the petitioner can be fixed with the liability of having served 1 year, 9 months, overstaying service. You know the apex court decision in this regard. Wrong fixation of pay,
Yes.
overstaying of service, unless it can be shown that it was due to some mischief on the part of the employee concerned, he should be held responsible.
Your Lordship, here, with regard to his early appointment in IPR, those documents were no longer available. The records were not available either in the parent department or with the Industry and Commerce. The documents were not available. Initially, when the petitioner retired, the file was processed for pension and pensionary benefits. But the AG office, they sought clarifications stating that excess allowances were drawn by the petitioner. So basing on that, inquiry was set up. And on inquiry, it was found that he had overstayed his period. But the PNR stated that since during his overstaying of period, the government had utilized his service. So his overstayed period will be, they have agreed to condone his overstayed period. And this was put up before the cabinet for approval. But the cabinet rejected that condonation and stated that he should reimburse his money.
Where are those documents?
It's in the annexure.
Not the cabinet, the PNR's observation.
It's in my affidavit, Your Lordship.
Page 19, annexure 5 of the Honorary Affidavit.
Page 19.
Page 19, annexure 5 of page 14, my lord. Annexure 5, annexure 5
Annexure
of the
5,
Affidavit of
page
Opposition.
14.
Can I read, my lord? Annexure 5.
Just a minute. Yes, read.
PNAR Department, OM Branch 1. The matter has been examined and we agree to the continuation and regularization of the period of overstay in service committed with effect from 1/11/2009 to 27/7/2011 in respect of Shri H. Thenongpom, Functional Manager, retired, subject to the following. Approval of the Cabinet. Number 2, the period of overstay in service from 1/11/2009 to 27/7/2011 shall not be counted as qualifying service for pension benefits. The pay and allowances availed by Shri H. Home against the said period of overstay in service shall be treated as honorarium since the said official service was utilized during the tenure in question. Number 2, further, in terms of the Cabinet's decision taken in its meeting held on 13/1/2020, copy of the minutes placed at P67, the Industries and Commerce Department is advised to submit the proposed continuation and regularization of the overstay period in service of the officials Shri H. Thenongpom to the PNR Department, AR branch for further necessary action. This has the approval of the Commissioner Secretary, Personnel and Administrative Reforms Department. So and so, dated 5/3/2020.
What is this AR branch again? Now, this is a note by the OM branch.
Yes, my lord.
They say that the proposal has to go to the AR branch again. Then how did it land up before the Cabinet? For the condition number 1.
Yes.
Observation number 1.
They have put up to the Cabinet and the Cabinet, they have turned down, my lord.
Yes, where is the Cabinet?
Page number 20, my lord, Annexure 9.
Yes, please read that.
Governor of Nagaland, Cabinet Secretary, Cabinet Cell, number so and so, dated Kohima, the 24th March 2022. Subject minutes of the Cabinet meeting held on 23rd March 2022. The undersigned is directed to forward herewith an extract of the minutes of the Cabinet meeting held on 23rd March 2022 for kind information and necessary action by the concerned department. Agenda number 5. Cases for continuation of our stay in service. The Cabinet did not approve the proposal and directed that the overstay period served by the official should be reimbursed by the official concerned. The Cabinet also decided that penalties should be imposed on the aiding HODs controlling officers concerned on account of delay in releasing the officials on superannuation. Suitable remarks should also be inserted in the parts of the concerned HODs controlling officers. Further, the Cabinet also directed the Industries and Commerce Department to contact in the Gauhati High Court in view of the contempt notice served to the Industries and Commerce Department on the issue of one employee under the department for overstay in service. This was issued on 24th March 2022.
Okay, Government Advocate, what has happened to the airing officials?
With regard to that, Your Lordship, I have no information.
But I am retired since 2011. Now it's more than 10 years. My pension has not been paid. I want that my pension should be paid at the earliest. That's all, my lord.
That's why we are looking into the matter now. But we have to ask few questions here and there. See, the Cabinet has decided will not condone.
Yes, Your Lordship.
He has to pay. Now, who are those officers who have not released him? We also punish him. So what steps have you taken? You have no instruction on that.
Yes, Your Lordship.
So that is the long and short of your case,
Yes.
isn't it? How complicated it is. You have served from 1970 through various capacities,
Yes.
ultimately released in 2011.
11.
It's so turned out that you have overstayed your service for 1 year and 9 months. And decision was taken to condone it.
Condone, yes.
But the Cabinet
Cabinet
says
has
that
turned down.
we will not condone. So, have you impugned the Cabinet's decision here?
No, my lord.
Then?
My lord, they have not come, yes, as
What
I
have-
want that if
What have you impugned in your writ petition? What have you challenged?
I have only prayed for early release of my pensionary benefits, my lord.
But you must be aware of the fact that what is the reason for not releasing your your pension? There must be a good reason. So you should have tried to find out.
Yes, my lord.
Instead of saying that release my pension.
I have advised the petitioner, but if I again file another fresh petition challenging the governance minutes, again, it may delay the matter again. So he don't want any further delay.
No, that, of course, the client will say that, but as a counsel, you also know the process.
Yes, my lord.
See, when you file a writ petition, forget about your case, any writ petition, it's so transpired that after exchanging few pleadings, it happens that there is something here which has stopped you from getting the relief. And when you get hold of that document, which was not in your possession at the earlier point of time, then what do? You seek an amendment. Okay, unless I challenge this, I will not get the relief. So I need to challenge this. That you should have done. Just one document. You could have just filed one small application that I would like to incorporate this as a challenge because this has stopped me from getting the relief. And you'll file a recast petition. How long will that take? That is the procedure.
Yes, my lord, I agree with that.
Now you will say, of course, the hands of the courts is not tied. 226 is very wide. You can also mold the relief. All those things will come, your argument. I know. It's preferable that you come step by step. Because coming to court is the last resort. Nobody enjoys coming to the court.
Yes, my lord.
They come because there is some great difficulty. So when you build up your case, it has to be meticulous. So what other submissions do you have? You have brought some authorities.
Yes, my lord.
Let us see.
Citations, my lord?
Yes. Or do you have any other submission to make?
No, my lord. My only prayer is that my pension should be released at the earliest, and for the delay post for releasing of my pension, I should be paid interest for also.
Where? Is there a prayer like that?
Yes, my lord.
Where?
My prayer number 3, my lord. Page number 12. Direct the accruals to pay an interest at the rate of 8% per annum from the date of the petitioner retirement till the date of payment.
Yes.
I may be allowed to refer to the judgment passed in 2022 2 GLT 654.
How much? 2022?
2 GLT 654. Para 7, 8, 9, 10, and 11. This is regard to delay in releasing of pensionary benefit.
No, see, delay is one thing. Now we know the reason for the delay. You already know the reason for the delay. You have not challenged that. But in spite of that, we are hearing you. And you need to bring some authorities regarding that. You cannot
recover.
Put the responsibility on me for overstaying the service because it was not your fault.
Yes, my lord.
And if it's not your fault, then they should not delay the matter and release the entire thing to you.
Yes, my lord. 2019 1 GLT 684.
2019
1 GLT 684.
Para
2011 684. 684 para 11, my lord. Para 11, my lord. Merit, my lord.
Yes.
In Rafaq Masjid Supra, the Supreme Court at Para 18 laid down some instances where recoveries by the employers would be impermissible in law. It would be profitable to extract the aforesaid paragraph 18, which read as follows. It is not possible to postulate all situations of hardship which would govern employees of the issue of recovery where payments have mistakenly been made by the employer in access to their entitlements. Be that as it may, based on the decision referred to herein above, we may, as already referenced, summarize the following few situations wherein recoveries by the employers would be impermissible in law. 1. Recovery from employees belonging to class 3 and 4 services or group C and group D services.
Okay, I've read it. See, now here the catchword here is mistakenly made. So now, is there any case in your case that it has not been mistakenly, it was mistakenly done, and you are not at fault? Where is the authority in that regard? That you have no role. You should have been released by them. Why did they not release you? You are not at fault.
2022.
And government also does not have the instruction that it was these officials who had mistakenly let you serve. And they have not taken any action. Whether they have taken action or not, that is also not before this court. And by the way, where is that? There was some inquiry done.
Yes, Your Lordship.
Where is the inquiry report?
Page 12, Annexure 4.
Of your affidavit?
Yes, Your Lordship.
Minutes of the inquiry committee held.
Yes, Your Lordship.
What does this say in sum and substance? Is it just because due to non-availability of past records?
Yes, Your Lordship.
Let us read this. Please read this.
Yes, my lord. Minutes of the inquiry committee held on.
No, you read from the first paragraph. In compliance.
In compliance to the direction received from the government by letter number so and so dated 20th May 2019 and on the observation made by the PNR department relating to excess payment and allowances drawn by Shri Tenom Pom, retired functional manager, the department has constituted a 3 members internal inquiry committee to study the matter and submitted a report to the government enclosed. Accordingly, the inquiry committee held a meeting on 12th June 2019 in the office of the Director of
Just a
Industry
minute. Who are these officials? Joint Director Administration of which department? Assistant Director Administration of which department? Is it the accounts? Or from the Industries and Commerce?
From the Industries and Commerce department, it appears.
Of course, it says in the office of the Director of Industries and
Yes.
Commerce. But it may also. All right, anyway, please continue.
Date of birth in respect of Shri Tenom Pom as recorded in High Court, High School Leaving Certificate HLC examination 1978, which is 2/3/1958 is found to be true and correct. Number 2, record of appointment order of Shri Tenom Pom to the post of handyman under IPR department is neither addressable in the department nor is addressable in the IPR department. A letter received from the IPR department number so and so dated 12/10/2018 is enclosed.
What is this? What is this? 12/10/2018.
It is a letter received from the IPR department saying that the documents regarding the appointment of the petitioner as handyman is not available in the office.
Okay. Then, number 3.
It is an admitted fact that Shri H. Tenom Pom had tempered his date of birth in his service book, which is a serious offense as per the service to conduct rule. The committee was of the view that the age tempering was deliberately done in order to show that he had been appointed to the post of handyman at the age of 18 years. Otherwise, as per the actual date of birth, he joined service to the post of handyman at the age of 12 and 9 months. However, there is no record of his appointment to the post of handyman in IPR as well as in the department.
What is this? Tampering. Tampering of what?
Of age, date of birth.
How?
Well, it appears from here, the report that there was some tampering of the date of birth.
Oh, just a minute. See, they say that your date of birth accepted is
1958.
Oh, 1958.
Yes, my lord.
But this annexure which you have shown me, it says 1952. So if you're born in 1958, you will be only 12 years, 9 months when
Yes,
you joined
madam.
the service in 1970.
Yes, madam.
Otherwise, as per his actual date of birth, his joining service to the post of handyman's age so and so.
Yes.
However, there is no record of his appointment to the post of handyman in IPR.
As well as in the department.
IPR is?
Information and Public Relation.
What is the annexure which you've shown us? Annexure A of the writ petition?
Annexure A is my memorandum by which I was brought on deputation.
Industries.
Industries, my lord.
That is different, isn't it?
Yes, different.
Not IPR.
Not IPR.
What were you in IPR?
I was a handyman. Initial appointment.
Handyman in IPR.
Yes.
So the first document available is only your offer of appointment.
Yes.
That is in 1983.
By which I was offered the post of the post of Inspector of Industries and Commerce, my lord. Indian Address 1983. Yes, my lord. Annexure A, page number 15 of my writ petition, my lord. 1983. 20th address. By this memorandum, I was offered the post of Inspector of Industries. Subsequently, by order dated 23rd September 1983, Annexure B to the writ petition, I was appointed as.
So if you go by the age of date of birth as 1958, how old were you when you were the Inspector of Industries?
58, 68, 78, 88. I am about 25 years, madam.
25 years.
Yes.
Does anybody get appointed as inspector at 25 years of age? Something wrong here. So, number 3 is that finding. They have accepted 1958 as a year of birth.
Thereafter, I was appointed as Inspector of Industries and Commerce on deputation, my lord.
No, please complete the thing. The inquiry report, number 4.
Number 4.
Page 13.
Page 40,
13.
Number 4, due to non-availability of the past records of the officer prior to his joining of service in the Industries and Commerce Department, his length of service was calculated from the date of his joining to the Industries and Commerce Department as Inspector of Industries and Commerce on 29/3/1983, which resulted in overstay in service and excess pay and allowance drawn. Recommendations. In the light of the above findings, the inquiry committee, after thorough examination of the case, have come to the conclusion that the department is also partially to be blamed for not releasing the officer on time from service. The committee therefore suggests and recommends that in the interest of upholding justice and on humanitarian ground, Shri Thenompom, retired functional manager, be made to recover 50% of the excess amount drawn due to his overstay in service, and that 50% of the amount may be written off on humanitarian ground. Submitted to the Director of Industries and Commerce for onward submission to the government for further necessary action. So my line of service was completed from 29/3/1983.
So what decision was taken?
Thereafter,
This
they
annexure
have-
5.
Yes, annexure 5. They have forwarded to the PNF, and then the PNF has condoned my overstay. Thereafter, it was forwarded to the cabinet for decision, and then the cabinet has turned down. That's-
So it is not that there was nothing regarding this. There's something here. You have not disclosed your correct age, date of birth. So, meaning thereby that you have invited trouble for yourself. What is your date of birth? You come to page 14 of the writ petition. You have not even disclosed your age. You are very secretive about your age.
No, my lord. Since I'm a retired government servant, now the
You have already retired, so
Second
why
March.
should you hide your age? Nobody will trouble you. But you have not disclosed your age. It's very interesting.
2nd March 1958, my lord, as per my HLCL certificate.
Where is that? No, where is that? From where you bring that paper? Why you bring papers like that?
No, my lord.
It should be a part of your repetition. This is my age. What are they talking about? My age is this. You should say that. You have not said that. As per the instructions from the Supreme Court, people who are senior citizens should be given preference in hearing the matters. So that's why that affidavit is there, giving the age. From there only we can find out, okay, this person is this age, so some preference should be given. But here is a case your affidavit does not disclose. So on what basis will you get that kind of preference? Of course, that's another aspect, but you should have disclosed it. Yes, what else? You have shown me that authority.
Yes, my lord.
Correct?
Yes, my lord.
2019, 1 GLT.
684.
So this is regarding payment which was mistakenly made.
Yes.
So whether you were also mistakenly continued.
He was mistakenly allowed to continue.
The inquiry report says that you have not disclosed your age properly. That is why, since there were no records also. Can you avail that benefit? What is the other judgment?
The other judgment is 2022 2 GLT, my lord, 656. Para 7, 8, 9, 10, and 11, my lord.
656.
656.
Paragraph?
7, 8, 9, 10, and 11, my lord. Married, my lord.
Yes.
Paragraph 7. It may be noted that the petitioner claimed that he was initially appointed as assistant teacher on regular basis in the Education Department, Government of Manipur, by order dated 27/1/1972, and thereafter he was sent to ADC Senapati on deputation. While on deputation, he was allowed to retire from service on attaining the age of superannuation with effect from 29 to 2008, subject to the approval to be granted by the state government. But the approval was not granted by the state government despite several representations being submitted by the petitioner. When the petitioner approached this court by way of a writ petition being WBC number 563 of 2016, it was disposed of on 17 2016 by this court with the direction that the state government should issue appropriate orders so that the petitioner could enjoy his pension and retirement benefits within 2 months. Therefore, this order dated 17 2016 had attained finality when the state government's special leave petition was dismissed by the Honorable Supreme Court on 14 to 2020. It ought to be complied with by the state government, and having no alternative, the state government is issued the order dated 19/10/2020 towards the compliance of this court's order. 8. The contention of the counsel appearing for the petitioner is that despite the order dated 19/10/2020 being issued by the state government, the petitioner has not yet been given his pension and retirement benefits. The short question that arises for consideration by this court is as to whether the issuance of the order dated 19/10/2020 by the state government would suffice in the sense that it would serve the purpose of complying with this court's order dated 7/10/2016. The answer is in the negative, for the reason that even after a lapse of more than a year from the day of issuing the said order dated 19/10/2020, the petitioner has not yet been given the opportunity to enjoy his pension and retirement benefit. There is no guarantee that the needful would be done by the state government within a reasonable time from now onwards. Para 9. In the state of Kerala versus M. Padmanabhan Nair 1985 1 ACC 429, the Supreme Court held as under. Pension and gratuity are no longer any bounty to be distributed by the government to its employees on their retirement, but have become, under the decision of this court, valuable rights and property in their hands, and any culpable delay in settlement and disbursement thereof must be visited with the penalty of payment of interest at the current market rate till actual payment. It has further been held since the date of retirement of every government servant is very much known in advance.
Mr. Counsel, let me interrupt you. I'll just take a break for 5 minutes. I'll come back.
Yeah.
Yes.
R9, my lord. In State of Kerala versus M. Bhatmanathan Nair, 1985, 1 SCC 429, the Supreme Court held as under. Pension and gratuity are no longer any bounty to be distributed by the government to its employees on their retirement, but have become, under the decision of this court, valuable rights and property in their hands, and any culpable delay in settlement and disbursement thereof must be visited with the penalty of payment of interest at the current market rate till actual payment. It has further been held since the date of retirement of every government servant is very much known in advance. We fail to appreciate why the process of collecting the requested information and issuance of these two documents should not be completed at least a week before the date of retirement, so that the payment of gratuity amount could be made to the government servant on the date he retires or on the following day, and pension at the expiry of the following month. The necessity for prompt payment of the retirement dues to the government servant immediately after his retirement cannot be overemphasized, and it would not be unreasonable to direct that the liability to pay penal interest on these dues at the current market rate should commence at the expiry of 2 months from the date of retirement. On top of that, in a cantina of decisions, the Honorable Supreme Court held that withholding of pension and other retirement benefits of retired employees for years together is not only illegal and arbitrary, but a sin, if not an offense, since no law has declared so. The officials who are still in service and are instrumental in such delay causing harassment to the retirement employee must, however, feel afraid of committing such a sin. It is morally and socially obnoxious. It is also against the concept of social and economic justice, which is one of the founding pillars of our Constitution. Para 10. In view of the aforesaid circumstances and the law laid down by the Honorable Supreme Court, it is imperative on the part of the state government to take immediate steps to ensure that the petitioner enjoys his pension and retirement benefits at the earliest possible. It is unfortunate that the petitioner, after having retired in the year 2008, has not been able to enjoy his valuable rights and property as held by the Supreme Court for the last more than 10 years, and that too after the order dated 7/10/2016 having been passed by this court. It may be noted that an order passed by the court is binding between the parties and will have to be complied with by them. The failure to do so will attract the provision of contempt of court. Simply and truly speaking, the scheme of the Constitution envisages that an appeal can be preferred before the High Court against an order passed by the subordinate court following the procedure prescribed in law, and likewise, an appeal can be preferred before the Honorable Supreme Court against the order passed by the High Court. The order passed by the Honorable Supreme Court is final. This has exactly happened in the present case for the reasons that the state government did lose the battle upon Honorable Supreme Court, and therefore the compliance with this court order dated 7/10/2016 by the state government is indispensable for the ends of justice. In fact, the petitioner has been unfairly and illegally denied the opportunity of enjoying his pension and retirement benefits. 11. For the reasons stated here and above, the instant petition is allowed with the direction that the respondent shall compute the pension and retirement benefits of the petitioner and pay him the amount thereof within 3 months from the date of receipt of a copy of this judgment and order, with interest thereon at the rate of 8% per annum from that of his retirement till the date of payment. There shall be no order of the cost. I'm also similarly associated with this.
Yes, what else?
My Lord, my only prayer is that let my pension be initiated at the earliest. It may be completed within a given specific period, and that I may be enjoying my pensionary benefits.
Okay. Let me hear the other side.
Your Lordship, on retirement, the department had processed his papers for his pensionary benefits, but as stated earlier, the AG had sought for clarification because of his overstay, excess allowances were drawn. Then after that, inquiry was set up and it was found that he had overstayed. PNR condoned that, but coming to the cabinet's decision, it was stated that condonation was not approved and he's to reimburse the amount. So So your lordship, if he reimburses, then pension might be released. Because here again, your lordship, the AG has not been made a party. From the department's side, the industry and commerce, they have sent the file to the AG. Now AG is supposed to process the pension. So from our side, we have sent the file. So when they have when they have received the file, they put up the clarification. So the file is with them. This is clear that the file is with them. From our side, we have done what is necessary, your lordship.
This minutes of the inquiry committee, this inquiry was constituted by the communication 20th May 2019.
Yes.
Do we have that letter? In the earlier round of litigation, did you file counter affidavit?
Yes, your lordship. There, the documents must be there.
Come to page 9 of your counter affidavit. Clarification.
Yes, your lordship.
Just read that.
Clarification regarding the excess pay and allowances drawn by Shri H. Tenongpom. In inviting a reference to the Government of Nagaland Industry and Commerce Department, White Letter number 141 2001 dated 27/7/2011, on the subject cited above, I am to state that the government has released Shri Tenongpom, functional manager from government service on 31/10/2009 on completion of 35 years of service in terms of Section 3.1 and Section 3.2 of the Nagaland Retirement from Public Employment Second Amendment Act 2009. But as per last pay certificate issued by the Treasury Office, it is seen that the office has drawn pay and allowances up to 31/7/2011, that is for 21 months, excess pay and allowances, which is to be recovered. In view of the aforesaid fact, the decision of the matter of 2009, whether the excess pay and allowances drawn by the officer from 1/11/2009 to 30/7/2011 be intimated to the officer for early disposal of the case, as early action in this regard will highly be appreciated.
What does it mean? In view of above?
In view-
Fact,
The matter be
the decision of the matter
of 2009, whether the excess pay and allowances drawn by the officer from 1/11/2009 to 31/7/2011 be intimated to the office, to this office.
what does it mean? Does it mean that the office should be informed whether he has actually withdrawn the money or not? Or what? How do we understand this paragraph? Then subject says clarification regarding.
Yes, Your Lordship.
So the language kind of, it's a bit not very direct. Anyway, it seems that they have detected
Yes, Your Lordship.
21 months overstay.
Yes, Your Lordship.
So they are basically saying, what do you intend to do about it? Please clarify. Then come to the next page.
This is the PNR's observation. The matter has been examined and following observations are made. The date of birth recorded as 2/3/1952 in the HSC admit card of 1978 is respect of the official Shri H. Tenongpom appears to be false and incorrect. This is because the official concerned could not have possibly entered service at the age of 12 years and 9 months as handyman on 2/12/1970 in the Information and Public Relations Department. It is also noticed that the date of birth entered in the service book has been tampered with, as it is seen that overwriting of the same has been resorted to. It is hence quite clear that a serious case of fraud has been committed by the official Sri Tanongpom. In view of the above, the Industry and Commerce Department is requested to immediately institute a detailed inquiry into the matter and submit a report thereof to the PNR at an early date.
So did you have an inquiry or not?
Yes, Your Lordship. The inquiry,
In the sense that involving the petitioner,
yes, the petitioner's case was inquired into. The report is at Annexure 4.
no, Annexure 4 is a member of convener and 2 members are there. Petitioner has not participated. In view of such discovery, a shock cause should go to him. What is this? Your date of birth given is this. And your service book is tampered with. Please explain. Then proceed accordingly. Instead, some inquiry was done, in-house inquiry by 3 members who gave some recommendation. Then again, this was sent to the PNR. PNR was considerate enough, saying that, well, we'll condone. But the cabinet, upon seeing all these things, said we cannot condone. He should recover. So it is not as plain as it looks. There is something wrong with your service book, and you could not have entered service at the age of 12 years. So these things are there. And you have not even sought to challenge this decision. And you're only praying for early release. You have not made the AG a party also, like rightly said by her. Is there any concept of provisional pension in Nagaland?
I have no.
Provisional pension. Pending finalization of the main thing, some provisional pension is given so that the pensioner enjoys
I'm not
this.
aware of this.
Can you get instruction on that?
Yes, Your Lordship.
We'll fix this matter on Monday again. Just find out
Yes, Your Lordship.
what is the practice, what is the possibility of having a provisional pension. Now, somehow or the other, we have to decide this case. I don't intend to keep it pending. This way or that way, we have to decide. Please write down, list the matter again on 27th of March 2023. Stop. Meanwhile, the learned government advocates shall obtain instructions. Regarding grant of provisional pension to government servant, comma, the modalities and provisions thereof. I think you've understood, isn't it? Provisional. Is there any case of grant of provisional pension earlier? Even if it's not there, can it be granted? And under what condition? That is what I want to know. Within the file, yeah, print out. All right.
Item number 26.
May it please your lordship.
Yes.
I'm appearing on behalf of my senior Muaz Jamir on behalf of the petitioner. Lordship, in this matter, the government is yet to file their affidavit.
Oh.
Lordship, on behalf of Mr. N. Angami, my colleague, kindly grant some time to file affidavit, Lordship.
How much time?
3 weeks, Lordship.
As paid for by the United States Council. Further 3 weeks' time is granted for filing counter affidavit.
Obliged, madam.
Just give me the 35. Dika, you one more line you write, the previous case. Item 22, no? What they say is the matter?
27/3.
Hmm?
This is the matter again on 27/3/2023. Meanwhile, the government allocation.
Okay, 23. After that, you just add. Along with WPC number 150 of 2019 and COPC number 14 of 2021.
Item number 32.
My please, Your Lordship.
Yes.
The state respondents here to file counter, Your Lordship.
Lordship, I have a similar prayer on behalf of Mr. N. Angami.
Same order, 3 weeks.
Item number 33. Lordship, similar prayer, Lordship.
33 also similar order?
Yes, Lordship.
Item number 36.
Yes, this was mentioned in the morning.
May I please, Your Lordship?
Yes.
Your Lordship, the petitioners are a batch of work charge employee who have served and rendered the department for 35 years and are now retired
Yes.
and are claiming for regularization as well as for pensionary benefits. Your Lordship, in Annexure 4, Annexure 5, page 125. The government, the respondents have already stated that the petitioners are entitled and it is under process. However, Your Lordship, till date, there is no such positive outcome from the department.
How many petitioners are there before this court?
20.
20. And out here, there's only 12 of them. Page 125.
Yes, Annexure 6.
Are the petitioners included
Your
in
Lordship,
this list?
Earlier, the petitioner 1 to 12 made file a writ petition.
And what happened to that writ petition?
And then this honorable court was pleased to dispose of the writ petition with a direction to dispose of the representation made by the petitioner. And then that was,
Where's the order? Have you enclosed that in your writ petition?
Lordship, it's in page 128, Annexure 7.
These are different petitioners, is it?
Yes, Your Lordship.
In WPC number 340?
Yes, Your
12
Lordship.
of them.
Yes, 1 to 12. 1 to
And,
12 filed the writ
yes.
petition.
And they are the names appear in this page 125. Or what? Yes. Court directed,
to dispose of the representation made by the petitioners.
which is pending, should be intimated to the. So pursuant to this direction, this page 125 was passed,
Yes, Your
or I
Lordship.
mean, communication was given.
Yes, Your Lordship.
Your names are included in the 12th phase, which is under process. And the present petitioners are different batch,
No, same batch.
same batch.
Yes. And then from the petitioner number 13 to 20, that has been included in this writ petition.
Petition number 13.
13 to 20, yes.
Okay, 13 to 20 are new.
Yes, Your Lordship.
But
They've
whether
also- this 13 to 14, 13 to 20 also made a representation. That is in page 122, annexure 4. That was also replied by the respondent.
Where?
Reply is in page 122, annexure 6.
No, the 122 is the representation.
Yes, reply. Reply is in annexure 6, page 122.
No, 122 is the letter by the petitioners to the engineering chief. This is not a reply. Annexure 4.
Annexure 6, 126. Sorry, Your
Uh-huh.
Lordship.
126.
Page 127 is the typed copy, Your Lordship.
Okay. These are another 8 persons. 8 plus 12.
Yes, Your
Total
Lordship.
20 petitioners.
20 petitioners.
Okay. Your names are included in 12 page, which is under process for regular. This means it's regular length. Yes. Morning, you wanted some time, isn't it?
Yeah, Lordship.
Now, if you go to, are you handling the matter or somebody
No,
else?
somebody else, Lordship.
There's a thing. Who's handling the matter?
Tipapong.
Where is he?
Lordship, he's indisposed, Lordship, so if some time may be granted, Lordship.
No, definitely will grant time, but the thing is that this thing also has to move forward, no? So this is the second time they're coming for the court. So court say that dispose the representation. And now what the government has done is that, yes, we are considering, this is time taking, so you wait. But that is not enough. You have to inform the court what steps we have taken. So on that note, I think you'll get instructions on this.
Lordship.
Okay, you inform Mr. Form also that he should get instructions on this. We'll not dispose it of as of today, but I'll just indicate these 2 letters saying that what steps have been taken should be informed to the court on the next court date.
Lordship.
Within what time can you get back to the court?
Lordship, if 3 weeks' time may be granted, Lordship.
No, not that much time. PHED. Where is the main office? Chief Engineer? Kohima, no?
Kohima.
Yes, get instructions from him.
Since Lordship is indisposed, Lordship, so if 2 weeks' time may be granted, Lordship.
All right. Please write down. 20 petitioners are before this court. Stop. Petitioner number 1 to 12 had earlier approached this court by filing WPC number 340/2021. Stop. The same was disposed of by order dated 14/12/2021 with a direction to the respondent authority concerned to dispose of the representation of the petitioners within a time frame. We'll stop. Next para. The case of the petitioners is that they have rendered about 35 years of service and retired on superannuation. Without being regularized. Stop. The petitioners are otherwise, no, the petitioners claim that They are to be regularized in terms of the office memorandum dated 17 March 2015, issued by the which department? Personnel.
Yes.
Have you annexed this in your?
Yes, Your Lordship.
Where is that?
Page 112, 112.
112. Issued by the Personnel and Administrative Reforms Department, within bracket, Administrative Reforms Branch, comma, Government of Nagaland. Full stop. The Chief Engineer, PhD, Sanitation and WSSO, White communication dated 26/10/2021, disposed of the representation of the petitioners in the following manner. A to A, abstract, page 25, 125. Stop. However, despite the above reply, since the petitioners have not got the benefit of regularization till date, they are again before this court, along with 8 other persons who are also similarly situated and who was also given a reply to their representation by the same authority on, what is the date? There is no date.
No date, but it's on February
On
2022.
Dated nil February 2021.
No, it's 22, Your Lordship. 22.
Is it 22?
Yes.
You have typed wrong then. The typed copy is annexure, page 127, isn't it?
Yes, Your Lordship.
Something wrong with the typing, so it should be 2022. Okay, 2022, within bracket, annexure 6. Next para. Today, Miss
Sibong Jang.
Sibong
Jang.
Jang, Learned Counsel, submits that Mr.
Tipapom.
Thibapom, Learned Government Advocate, who appears for the state respondents, is indisposed, and that the matter may be adjourned for 3 weeks. Full stop. However, considering the grievance of the petitioners, as already indicated here and above, comma, the learned government advocate shall obtain instructions about the status of the process of regularization of the services of the petitioners to the court by the next court date. Stop. Let the matter be listed again on today's 23rd. We'll give them some time, all right? 17th of April, 2023. You want a copy of this order?
Lordship.
A copy of this order be given to Miss So-and-so during the course of the day for doing the needful.
Obliged, Lordship.
Much obliged.
Item number 37.
My pleasure, Lordship. Here the petitioners are seeking for time-bound scale of pay. And then the affidavit in opposition filed by the respondent 1 to 43, they have clearly stated that we are entitled for the time-bound scale of pay in their para 5 and 6, Your Lordship.
Now, before that, let us see your prayer.
Yes, Lordship.
Who are the petitioners?
Your Lordship, the petitioner 1, 2, 3, they are the representatives of the Workers Association known as the All Nagaland PWD Field Workers Association, Your Lordship.
Registered association.
Yes, Lordship. And then my prayer is at page 14 of the petition, Your Lordship.
14.
Page 1 for Your Lordship. At para 13.
In terms of the Rule 13 of the Nagaland Services Revision of Pay Rules 1993.
Yes, Lordship. Since the work charge employees they are governed by the ROP 1993, Your Lordship.
So where's the reply?
In the reply, Your Lordship, para 5 and 6, Your Lordship. Respondent number 1 to 43, affidavit in opposition.
Have you filed affidavit?
Lordship.
Available in the second file.
It's just a very thin.
Oh, it's here. Sorry. It's very thin, so that's why I missed it out. Which paragraph?
5 and 6, Lordship.
Please read.
That as for the averments made in paragraph 8 to 12, the deponent respectfully states that by a letter so-and-so dated 14/12/2022, the Finance Department had written to the Secretary Works and Housing Department, Nagaland, Kohima, stating that the work charge employees drawing skilled pay under ROP 1993 are entitled to time-bound scale as per Rule 13 of ROP 1993. As such, on considering the petitioner's claims and Rule 13 read with 2B of the Nagaland Services ROP Rules 1993, the deponent humbly admits that members of the petitioners association who are eligible under the scheme and yet to avail the same are entitled for the time-bound scale of pay. And the respondent authority shall consider their cases on the basis of the prevailing rules of the government.
All right. So how much time do you want?
Lordship, 8 months.
Huh?
8 months. A huge number of are involved, Lordship. If not more than 1,000, I think several hundreds.
Yes, Lordship, it can be done.
All right.
Lordship, and then I have a small prayer, Lordship. There are also some employees who have already been regularized, but then they are not being granted, Lordship. Work charge employees who are entitled for the time-bound scale of pay, Lordship. They've not been granted, but they've been regularized already, Lordship. And then in my legal notice, I've enclosed all the lists also, Lordship. So on that line, the direction may be given also, Lordship.
But they're not before this court, no?
Yes, Lordship. But then, but you were also part of the work charge employees.
So why do you want to
Lordship,
enlarge your prayer?
Lordship, that is exactly.
Then, Your Lordship, in the line with the affidavit in opposition, may be disposed of, Your Lordship.
You may file your representation on that since these people have been given, we
Yes,
have been
Lordship.
requested earlier, we also should be given. You give one representation, if it's not
Yes, Lordship.
looked into, then you are free to come. Let us not go beyond the pleadings. Okay. Heard Mr. Subuwati. This is item 37. Heard Mr. Subuwati, learned counsel for the petitioners, and Mr. Kiangami, learned government advocate, appearing for the respondents. Stop having regard to the nature of case projected by the petitioners and also the response given by the respondents in their counter affidavit dated 13/2/2023. The writ petition is taken up for disposal at this stage. Stop next para. The petitioners before this court are the All Nagaland PWD Field Workers Association, represented by its president, general secretary and joint secretary. To stop, the members of the said association having common grievance, they have approached this court through the association with the following prayer, page 14 and 15, A to A. Please abstract. Huh? Next para. Against the above prayer, the state respondents have filed their affidavit in opposition on 13/2/2023, wherein they have admitted that the members of the petitioner association who are eligible What is the scheme? What do you call the scheme?
Your Lordship, Nagaland ROB Rules 1993, Your Lordship.
Under the Nagaland, within bracket, revision of pay, close bracket, rules, 1993, are entitled to, no, will be entitled to the time-bound scale of pay. And that the respondent authorities shall consider the same as per the prevailing rules of the government. Stop. It is, however, stated that since the members of the petitioner association are in large numbers, sufficient time should be granted to the state respondents to undertake the process of granting the benefit of the time-bound scale of pay to those who are entitled. Stop. Paragraph numbers 5 and 6 of the counter affidavit is abstracted hereunder for ready perusal. Page 2 and page 3, huh? Paragraph 5 and 6. I'll just mark A to A again. Next para. Considering the above claim of the petitioner association and the stand of the state respondents in their counter affidavit, the writ petition is disposed of with a direction to the respondent authorities concerned to consider grant of time-bound scale of pay to the members of the petitioner association as expeditiously as possible and within the outer limit of 8 months from the date of receipt of a copy of this order. Yes.
Reply, sir.
For orders, item number 40.
Your Lordship, on behalf of Inohali, kindly grant 3 weeks time to file affidavit.
As prayed for 3 weeks' time is granted to the state respondents for filing counter affidavit. You put that word further 3 weeks' time is granted.
For hearing, item number 44.
Yes.
Your Lordship, in the last occasion, I was instructed to to clarify whether the post of Mason is still vacant. So, Your Lordship, the department has informed that this post is still lying vacant.
Okay, what was the case about? What is the case about?
My lord, my regularization was cancelled. I was regularized thereafter. My regularization was cancelled. So
Show me the regularization order.
annexure A2, batch 13.
Please read.
In the interest of public service, the undersigned is pleased to observe Srimati Supungla Sanctum work charge Chukali under the establishment of Executive Engineer BWD H Medical Engineering Division Kohima and do recolor cater against the sanction post in the scale of pen of so-and-so, grade P of so-and-so, plus all other allowances as are admissible under roles from time to time to similar posts in Nagaland with effect from the date of joining the post. The observation of service into recolor cater is purely on temporary and is liable for termination within 1 month notice. The period of service rendered by the incumbent under work charge period will be counted as qualifying service for pension benefits only. Other benefits like the errors, leave engagement and provision for of MSCP scheme shall be admissible only after the actual date of regularization of service. In the interest of public service, Sri Supungla Sanctum Chokali is posted under the establishment of Executive Engineer BWD Housing Medical Engineering Division, Kohima.
So, petitioner was working as work charge,
Yes,
Jugali.
yes, your
So he has
lordship.
been absorbed
Yes,
as Jugali.
yes, your lordship. Against the sanction post.
Okay, then thereafter,
Thereafter, I was not giving my salary. So I, along with 3 others, we've approached this honorable court for payment of salary. So, which was registered as WBC 10 of 2015. So while we approach this honorable court, the department has issued a show cause notice to us. So we bring to the notice of this honorable court, and this honorable court had directed the petitioner to reply to the show cause notice and dispose of the petition.
what was the shock cause notice about?
Show cause notice is annexure B, batch 14.
In violation of rules, you were regularized according to them.
Yes,
Show
your,
cause.
yes, your lordship.
So,
So I've replied to the show cause notice, but Instead of considering my case, my regularization order was cancelled. So I've approached this honorable court again. In one of the petitioner, who was a co-petitioner in WBC, then he was regularized, who was junior to me. There were 4 petitioner, your lordship. So one of them, he was regularized, one was expired, and then one, he could not approach this honorable court due to some difficulties. So I'm the only one who is approaching.
See, you were regularized.
Yes, your
And
lordship.
then you were not given your salary.
Yes, your
So you
lordship.
came before this court. In the meantime, they give you a show cause saying that the rules were violated
Yes, your
in
lordship.
regularizing your service.
Yes,
Then court said that no point keeping it pending. It was
Yeah.
disposed of, giving liberty to you to file a reply
Yes,
and
your
to come to the court again if you are aggrieved.
yes, your
So
lordship.
thereafter, what happened? You replied.
I've given the reply.
What does your reply say? That no rules were not
So-
violated.
Page 17, Annexure D. Page 17, Annexure D.
Please read paragraph 5.
That I was regularized after conscious decision was taken by the competent authority as per notification dated so and so Kohima, 6 December 88. All the engineering wings attached to various government departments in Nagaland except the Department of Nagaland State Transport, Geology and Mining, Agriculture has been amalgamated into the Department of Work and Housing with effect from 1/4/1989. Consequent upon the order, all the posts of engineering wings in various departments has had formed a combined cater in the engineering service of the work of housing, so regularization does not arise.
What are the departments which is amalgamated to the works and housing?
All the engineering division,
What are those?
medical, work and housing, and then electrical.
Medical? What do you mean medical? Medical is their engineering department.
Yes, I'm under medical engineering wing.
Medical
Yes.
or mechanical?
Medical.
So what was the show cause about? This is under the establishment of Executive Engineer PhD, H Medical Engineering Division, Kohima.
Has violated the
This may
rules.
without following the so and so.
Yes, your lordship.
So your absorption was done under the PWD H Medical Engineering Division.
Yes, your lordship.
And what according to them is violated?
You've stated that the engineer in chief has regularized NPWD has regularized my service. So I may be allowed to read the show cause notice. Page 14, the next should be.
No, that's what I was asking you. What has been violated according to them in your absorption?
You've stated that NPWD has violated the rules and regularized some work charge employees of medical department, which has detected by the department after filing this writ petition. So you've stated that the PWD has regularized the employee of the medical department.
But medical department means you are under the medical engineering division. isn't it?
Engineering department,
So it
yes.
is one of the division under the PWD.
Yes, your lordship.
So what is wrong in that? And which particular rule is violated? It just says that rules have
Yes.
been violated. There's no specific rule mentioned here.
Nothing was mentioned.
But yet you reply saying that all these various wings have been amalgamated
Yes, your lordship.
under the common combined cadre,
Yes,
except for the geology and mining, transport, agriculture, etc.
yes.
And what is the response? You get this
Cancellation of my regularization.
at page 19.
Yes, Your Lordship.
Just read.
In pursuance of the Honorable Court Order dated 24/7/2015 passed in WBC 10 of 2015 and in reference to the Shore Court's notice reply dated 19/8/2015, the service regularization of Srimati Tsupungla Sanctum Work Church Tukali was done not in conformity with the prevailing rules. Therefore, the regularization order number so in so dated 27/8/2013 of Srimati Tsupungla Sanctum Chukali under the establishment of Executive Engineer BWD Housing Medical Engineering Division Kohima is hereby cancelled with immediate effect.
Okay.
So that's the result I got.
Then what is this affidavit you have next? Page 20.
So this is the affidavit in WBC 10. They've given this affidavit, the government, the
Yes.
respondent.
Why have you annexed this? Oh, petitioners
yes.
are employees of Health and Family Welfare Department. Now this is, oh, you came in a group, three of you.
Four of us.
Four.
Initially, yes.
And what about the other three?
One is already been regularized. My junior, who was my junior, one is expired, and one could not approach this honorable court due to some difficulties, personal
see.
difficulties.
I see. Do you belong to the health department? Are you from the health department?
No, Your Lordship. I'm under engineering wing, medical department, but
They have stated in the affidavit of position, the petitioners are the employees of the Health and Family Welfare Department, Nagaland. Hence, their salaries was paid by the Department of Health and Family Welfare. Surprisingly, the former ENC regularized the petitioner's service against the rules of work charge employees regularization. So this is their case. If you are indeed from the Health and Family Welfare Department, can you be regularized under the PWD? Or if you are under the medical wing of the PWD, why should they say this? This affidavit is filed by 2 and 3. Who are 2 and 3? Commissioner Health, Commissioner Works and Housing. So what is wrong in the cancellation order? Yes, madam, what is your case? How do you claim that you should be regularized?
Your Lordship, one of my junior who was cancelled, who has also been cancelled, the regularization has already been regularized.
But that can that be a ground? Supposing the regularization is not in order, illegally regularized, then can you also claim similar benefit?
Your Lordship, it's not the fault of me because it's the fault of the department. So how can I be punished for the fault of the department?
What is the fault of the department?
Because I was regularized. I don't know who regularized me, but I was regularized. So I was happy. But it's the fault of the department, answering department.
No, can that be the ground that you were regularized at one point of time? So they cannot take it away from you.
And not only that, I'm not the only one because if your Lordship may kindly turn to page 28, annexure G2. The petitioner
20?
has 28, Annexure G2.
Yes.
So this is the RTI reply given by the department. So furnishing of information under RTI 2005. With reference to your letter number dated 21/7/2015 on the subject cited above, I am to furnish herewith the requested information as mentioned below. The number of all the work charge employee who were regularized through work charge and casual employee as per the Nagaland Work Charge and Employees Regularization Act 2001 is 67. As statement of names of the work charge employee who were regularized through Work Charge Employees Commission Regularization Act 2000 till date is enclosed. The number of the work charge employee who were regularized by Engineer-in-Chief NBWD Nagaland Kohima since 2011 till date is 273. The number of the employees should cause notice issue for irregular regularization since 2011 is till date is 48. So only 48% were issued show cause notice and the other person they never issued. So we are some few selected person whose regularization was cancelled because we've approached this honorable court to be our salary. So that's the reason why they've cancelled our regularization. But the other employee, they never cancelled their
Where is your
regularization.
statement? Where is your statement to that effect? That just because you approached the court for salary, they have cancelled?
As per the RTA reply, it's clearly stated.
No. You're saying that others have been given the benefit, we are not been given the benefit. Some of us are, including myself. The reason is that we have come to the court for salary, so they have recalled the regularization order.
Yes, Your Lordship.
Is that your pleadings here?
Yes,
Where?
para 12. That it is. So this is the para 12 on 31/7/2015. The petitioner, through her counsel, sought information through RTI, which was submitted on 31/7/2015 to the respondent. That the respondent in their RTI reply stated, dated Kohima 28.
No, it's not here. You don't read the same thing. You have already read this from the annexure. So the second para also does not say anything about that.
Yes, it is to be noted here in that mere reading of the mentioned RTA replied letter to the respondent that state respondent cancelled the regularization order of the petitioner on the mere ground that her service was regularized by Engineer-in-Chief NBWD. However, other remaining employees who were regularized by the Engineer-in-Chief NBWD were not even issued show cause notice. As such, this has not been done by applying sound and uniform rational method by the respondent authority, but purely on pick and choose policy.
So they have filed their affidavit in position?
Yes, Your Lordship.
Who are the respondents here? Health, then housing, works and housing,
Yes.
NPWD, chief engineer, engineer-in-chief. No, the thing is that why have you made the health department a party when you say that you are not a part of the, you are part of the engineering wing? Your substantive post or your initial appointment is in the health department and attached to the PWD. Is it like that?
Your Lordship, there is a confusion for my service appointment, so I've employed medical department as a respondent.
You are also confused.
Your Lordship, here the petitioner was initially appointed by the medical director,
Medical director of what? Which department?
Health and Family Welfare, Your Lordship.
Okay.
In her annexure 1, the first annexure, her appointment order, page 12, A1.
Page? Affidavit, whose affidavit?
The writ petition, in the writ petition. The main petition,
Oh, in the writ petition.
Page 12, A1.
What is this? Medical Engineering Division.
here the, your
Page
lordship,
12. Page
yes, your
12.
lordship. Here the appointing authority is the Director of Medical Service.
No, but see the top of the letter, na? Order, Office of the Executive Engineer, Medical Engineering Division. This is not the Health and Family Welfare Department.
But your
They have
lordship,
a Medical Engineering Division under the Engineering Department. You, as a government council, you know better.
your lordship, in
Because we
the,
don't know which department is which department. And whether whether there's a medical wing under the engineering department or not, that you should know better.
in the affidavit in opposition of respondent 1, 3, 4, and 6, that is the NPWD.
This is filed by whom?
The
Engineer in chief.
Yes, your lordship, engineer in chief.
What does he say?
In paragraph 8, the third line, he says, the deponent begs to state that cancellation of the petition regularization order was not only on the ground of her service was regularized by the engineer in chief, NPWD, yet she was appointed by the Director Medical Service. Hence, she should be regularized by the Director Health and Family Welfare Department of Medical, as she is a medical employee. The engineer in chief is admitted to this, that she is a medical employee. So her regularization should also be done by the Department of Health and Family Welfare. And your lordship, in the affidavit in opposition of Health and Family Welfare,
Just a minute. You all should clarify first regarding how about this medical engineering division. What is this division? Who are the persons functioning under this division? Are they employees of the health department who have come there on temporary basis, or they belong to the cadre of the engineering department itself? That will clarify things.
your lordship, at paragraph 8, the engineer in chief has stated clearly that she is an employee of the medical department.
On what basis is he saying that? Because the annexure A of the writ petition, this is an order issued by the Office of the Executive Engineer, not by the Health and Family Welfare Department. That was in the way back in 1993. She was appointed by the Director of Medical Services.
Yes, your lordship.
But the Office of the Director of Medical Services, on top it says Office of the Executive Engineer. Yes, counsel for the petitioner, how do you explain this? If it's Office of the Executive Engineer, signatory should be the Executive Engineer or SDO or somebody. How come the Director of Medical Services has given the signature? Is there something wrong with this annexure? Have you understood what I'm saying?
Yes, your lordship. But your lordship,
It could very well be a home department also, Government of Nagaland Home Department, and below Director of Medical Services. Can it be like that? It cannot. So what is, who appointed you, under which department? That has to be clear. And the question of your regularization, whether it was rightly done or wrongly done, will come. What is your identity, your initial recruitment? Because engineering chief says that you should be regularized by director, not by chief engineer or engineering chief. This has to be clarified. You cannot just say that, okay, somebody has been regularized, I also should be given. My junior has been regularized, I should be given. That is another matter altogether. Supposing that was done wrongly, a wrong benefit cannot be claimed. You cannot get such kind of benefit like that just because somebody has been given like that. Then even in the cancellation order, it just says that violation of rules. Which rule is violated? Just saying rules will not do. You have to specify which rule. In violation of the provisions of Nagaland Work Charge and Casual Employees Commission Act 2001.
Your Lordship, if
What
I
is
may,
this?
the Work Charge and Casual Employees Commission, clause 5.
We'll come back at 2. We'll just find out.
Yes, Your Lordship.
What exactly has been violated and whether the petitioner is an employee of the health department or an employee of the engineering department. That we have to know.
May I please, Your Lordship?
Yes.
Your Lordship, in this matter, if I may be granted some time to get the necessary clarifications.
Yes, you should, I think.
Yes, Your Lordship. I've spoken with the department. They are also quite confused here. So if 3 weeks may be granted.
Petition is also confused.
And Your Lordship, if this can be, if direction can be given to get
What direction?
to get this clarified, whether the petitioner is an employee of the medical department or the PWD department.
We'll do that, see. There's no backup.
Yes, Your Lordship.
Where is my team? When can you get the instructions?
Your Lordship, 2 weeks may be granted.
2 weeks.
Yes, Your Lordship.
Why such a long time?
Your Lordship, these are all records, so
Please call the stenographer. If you come back to page 12 of the writ petition,
yes, Your Lordship.
this is an order signed by the Director of Medical Services. Today, what do you have under the Health Department? You have Director,
Yes, Your Lord. Principal Director.
Principal Director
Yes, Your Lordship.
of what? Medical Services?
No, Your Lordship.
How many directors do you have?
I think it's only Principal Director and below him additional Director, then additional.
You are also not very clear.
Yes, Your Lordship.
See, in other places, there are 2, 3 directors. Director of Medical Education, Director of Health and Family Welfare, and one more director, something like that. So, on top, I think there's a principal director again like that. So, anyway, here it's given as Director of Medical Services. But if you go to the top of the page,
Yes, Your Lordship.
Government of Nagaland, Office of the Executive Engineer. So it should have been the executive engineer who to sign. But then again, it is the director who is signing. Whether the director is working under the executive engineer, this is also another issue. Please write down. The initial appointment of the petitioner as work judge Jugali Right, order dated. What is the date?
20th September
1993 has been issued under the signature of the Director of Medical Services, Nagaland Kohima. Full stop. However, the order is under the heading Government of Nagaland, comma, Office of the Executive Engineer, comma, Medical Engineering Division, comma, Nagaland, Kohima. What is your claim that you're working under the
continued.
Huh? You're working under whom? Under which department?
Under medical engineering.
Which is under what? Full stop. The claim of the petitioner is that he is working under the Medical Engineering Division. Where? Kohima?
Yes, Your Lordship.
Kohima. And that his absorption in service has been illegally cancelled by the respondent authority concerned. Full stop. The affidavit in opposition of the respondent numbers 1, 3, 4, and 6 is to the effect that the petitioner was appointed by the Director, Medical Services, and therefore she should be regularized by the Director, Health and Family Welfare Department, as she is a medical employee. Full stop. Next para. In view of above, the question is as to whether the petitioner is an employee of the Executive Engineer, Medical Engineering Division, or an employee of the Health and Family Welfare Department. Stop. The learned government advocate, Ms. A. Ayemi, on the next date, shall obtain instructions and clarifications on the above point. List this matter again. 2 weeks.
After 1 week.
1 week.
Yes, Your Lordship.
Shall I say third or fourth?
Third.
List the matter again on 3rd of April, 2023.
Yes, Your Lordship.
But you must make that argument that just because somebody has been given, you should be given, also given. That may not be, it may not be sustainable. Because if somebody is given, wrongly given, then you cannot also be wrongly given. So negative equality cannot happen. It has to be positive. If that person was rightly given and you are on the equal footing, then you can claim. There's no doubt about it. But if that person was wrongly being a medical employee regularized by engineering department, there may be some difficulty. All right. That's all. Thank you.
Mesin lah tu cari guna gina. Skill lah super matter.
Nanti bi hudi udar bi asna nahi to na. Mesin lah tu muta lah boleh bi hudi udar. Ay ke lah cari.
Court.